In this segment, we're going to talk about how courts make decisions and the importance of stare decisis and precedent in that decision-making process. Recall that courts have two functions. They evaluate and interpret the Constitution and statutes, and they develop and apply the common law. In both of those functions, the court relies on and is guided by the principle of stare decisis, which means let the decision stand. Stare decisis, in turn, relies on precedent. Precedent is a rule established in one case that governs the decision of future courts. It means, in essence, that lower courts are bound by the decisions of higher courts, and that higher courts are bound by their own previous decisions. Let me give you an example of how that works. If a trial court is trying to determine whether the statement, "you're a jerk," is a tort, it will very likely be bound by an appellate court opinion that has determined that "you stink to me" is not a tort, because the factual situations there are similar. There are three distinct benefits to stare decisis. The first is fairness. As seen in the previous example, you want litigants who experience similar factual situations to have similar results. The second is predictability. Future litigants know that their situation will be judged by the same rules and standards that have been developed in previous cases, and that standard won't change. The last benefit is efficiency. Courts need not revisit legal issues or rules that have already been determined by previous courts and can focus instead on new and novel issues before the court. There are three factors to take into consideration when determining if precedent applies. The first is the structure of the court. Only certain courts bind the decisions of others. The second is the holding. So even if a court is bound by the decision of a previous court, it's only bound by the holding of that case and not by the dicta. And I'll explain what those terms mean in a moment. And finally, a court is only bound by a previous decision if the legal issue being considered is the same and the facts are similar. We'll come back to that one too. There's two types of precedent. There's binding precedent and there's persuasive precedent. Going back to the federal court structure and system, and using the Eastern District, Michigan as an example, you'll see that the Eastern District of Michigan is only bound by the decisions of the courts directly above it in the hierarchy. So on screen, you'll see that the Eastern District of Michigan is bound by Sixth Circuit decisions, and of course, also bound by Supreme Court decisions. The Eastern District of Michigan, however, is not bound by decisions from the Seventh Circuit. If the Sixth Circuit has not spoken on a particular issue, the Eastern District of Michigan might look to the Seventh Circuit for guidance. It might even be persuaded by the Seventh Circuit's decision and its reasoning, but it's not bound by the decision of the Seventh Circuit, and it can make a decision that's contrary to that Seventh Circuit decision. In a system like Michigan, where there's a single court of appeals, the same principle applies, but all trial courts in the Michigan circuit are bound by all Michigan Court of Appeals decisions, since there is just the one Michigan Court of Appeals. The appellate circuits, in turn, are bound only by the Supreme Court. They're not bound by their sister circuit decisions, so the First Circuit is free to disagree with a Second Circuit opinion. They are, however, bound by their own previous precedent. So a Sixth Circuit court that's trying to decide a case in 2015 will be bound by a Sixth Circuit decision that was made in 2010. The same principle applies to the Supreme Court. It is bound by its own previous decisions. However, the circuit courts and the Supreme Court does have the ability to overrule its own precedent in limited situations. The Supreme Court of the United States recently listed some of the factors it takes into account when determining whether to overrule its own precedent. And these include the age of the previous decision, how much parties have come to rely on that decision, whether that previous decision was well-reasoned, and whether either party is defending that reasoning. And finally, quote, whether experience has pointed up to the precedent's shortcoming. A somewhat trickier situation is involved when a state court is deciding a federal issue. In that situation, it is bound only by U.S. Supreme Court decisions and no other decisions of the federal court system. A federal court that's trying to decide a state issue, as it might, for example, when there's diversity jurisdiction, is bound only by the decisions of the state Supreme Court. Knowing which courts bind the decisions of others, however, is only part of the equation. A court is bound only by the holding of the previous decision. And a holding is defined as the decision of the court plus the operative facts. Those are the facts that make a difference, and the court's reasoning. Dicta is everything else. And it could include, for example, speculation by the court as to how its decision might be different if it were faced with a different set of facts. Lastly, the court takes into account whether a previous case is factually similar in deciding whether its precedent, its rule, should apply. Harkening back to the example of the trial court trying to determine if you're a jerk is a tort, and I told you it's very likely bound by the decision of the appellate court that has held that you stink to me is not a tort. The insults there are similar, and it's likely that that's binding precedent. But what if you have a situation now where the trial court is trying to determine if the statement, you're a drunk and a thief, is a tort? Is that similar enough to you stink to me, or are there substantive important differences between those two insults such that the results might not necessarily be the same? Determining the holding of a case and determining whether the two cases are factually similar such that the rule developed in one should apply to the next is a huge part of what we're going to be doing this year in legal practice, and also a big part of what you're going to be doing in your other classes this year.